Good evening, class. I'd hoped to be there in person tonight, but instead you were watching a recording of me. So if you raise your hand and I don't respond, it's because it's not live, it's Memorex. And you're showing your age if you know what that references to. Last class, I had y'all review some things on filings. And I wanted to tell you the reason I did that is because, number one, I think it's very important. It's very important to know the correct manner of how filings are done. And just a little story from my own practice here just last week or so. I am doing a probate for a friend of mine. Unfortunately, his father died. And I don't practice a lot of probate law, but I have done one or two. And I filed in probate court for the first time in a while. And in probate court, or in all courts, you're required to file something called a civil case information sheet, which basically says nothing other than who's filing the filings. And in civil court, they require that piece of the civil case information sheet to be on the front of your filings. And I found out that probate court wants it on the back of your filings, so they rejected my filings. And if this had been something with a statute of limitations, which fortunately it was not, I could have potentially missed a statute of limitations because I misfiled that document and had it rejected and had to refile it the next day. So how you file something with the courts does matter, and it's important to know how to do it and how to do it well. That's going to be a lot of your jobs if you go to work in a litigation firm. That's going to be something that you're going to be doing every day. I did prepare this. If you need to resubmit assignment, I just drafted this quickie little motion for something that you may do to request to resubmit an assignment. Basically, as you can see, it doesn't really say much, but I want the reason that you are requesting to resubmit an assignment. And I also am wanting you to recognize and tell me what your highest possible grade is. Remember that you can only get back half of the points that you have lost. So again, if you made a 70 and they're wanting to resubmit an assignment, your highest possible grade will then be an 85. When you do submit a motion like this, attach also your whatever assignment it is that you want resubmitted and regraded. And just assume that it will be granted because, quite frankly, it probably will be. Submit this through Blackboard. Do not submit it in email or anything like that. But as you do any other assignment, submit it through Blackboard. We are going to be proceeding and with a case from a plaintiff's point of view, and I wanted to start off by introducing you to what a successful plaintiff's case is. Plaintiff's case, you have to have three elements. These are not what you're going to learn probably about negligence or anything, but first of all, you have to have damages. You have to have something hurt. Those damages have to be caused by someone's negligence, and that person that caused the damages has to have some ability to pay. If you don't have any of these one of these three things, you will not have a successful case. It's worthless to have damages unless they were caused by someone's negligence. It's worthless to have negligence if you do not have damages. You must have all three. And I will say that in general, most plaintiff attorneys will tell you if you can only have two, you want damages along with an ability to pay, and you figure out who is negligent as you go along. But in general, you have to have, or not in general, in actuality, you have to have all three of these things. So what do? You've just signed up a plaintiff's case. First thing you have to do is let people know that you represent the plaintiff. You want to give notice to the other side, and you want to tell them who you're representing and what your claim is. Now, also, there are some other specific situations in which you are required by law to give notice. This includes the DTPA, Texas Tort Claims Act, insurance code violations, medical malpractice. There are probably some others, but those are the four main ones. In other types of cases, you are not required to give notice. It's just good practice to give notice. And you want to do so you can enter into some sort of settlement type negotiations. In general, I always recommend, and I think most people recommend, that you give notice to as many people as possible. You never know who might actually end up paying or being negligent when you first get a case, and you want as many people as possible involved. Here's an example of just a sample notice letter that I use. If you have this information, this particular letter, it looks like it's going to be addressed to an insurance company. You want to let them know their policy number, their claim reference, their claim number if you know it, their date of loss. You want to make things easy on them. You don't want them investigating too much. You want to send it certified mail so that you know that they got it. I include a little brief explanation of the accident, what happened. I also, if I have it, I attach a copy of the accident report. Tell you something, I do that so that they don't necessarily investigate the accident sometimes beyond what I send them. Something that happened to me early in my career, I sent a copy of an accident report. The investigating officer later amended the accident report after interviewing a witness and changed his opinion on the accident, went from the defendant being liable or responsible for the accident to my client being responsible for the accident. The insurance company never requested a copy of the amended accident report, and we actually settled the case based upon the original accident report that I submitted. That's why I tend to try to make it as easy as possible for them to so that they don't get too curious, so to speak. I also include something about the damages. I ask if it's to an insurance company, if they have obtained any records or bills of my client. I'd ask for a copy of them. I want to know what they have. I also ask for any recorded statements that my client may have given. I also, oftentimes, insurance companies get a release from your client or from a potential client to obtain information like medical bills and records, and I always revoke that because I want to know what the insurance company will have. Now you're probably asking, well, how do you know who the insurance company is? How do you know who the defendant is? Good place to start here is the police report. This is a standard form in Texas. All policing jurisdictions use this report. They are a wealth of information. You get driver's names. You can get the owner of the vehicle if it is different than the driver. Here you can get the insurance information. Here's been redacted. This is an actual police report from my files. You can get the policy numbers. This here would be the plaintiff's information. You can get the investigating officer and the fact that there's been a ticket written here. Here you know what jurisdiction investigated the accident, in this case, the Lumberton Police Department. Now, that's important to know because you're going to want to obtain a certified copy of this. Now, the big police departments, say the Department of Public Safety, Houston Police Department, you can probably request that online, sometimes with a phone call, get a certified copy. Some of the smaller jurisdictions, like Lumberton, or there may be others, you have to send a written request. You cannot get it online, but that's important to know. The second page here of the accident report, you can get, here's what happened to the car. It was towed away to Newman's Paint and Body, so you can then obtain damage information on how badly the car was damaged. Here you can get information on how badly people were injured as a result of the accident. You get a brief little narrative from the police officer on what he thinks happened, as well as why he thinks it happened. The accident report is a real wealth of information. Part of your job as a paralegal, or primary part of your job if you're going to work for a litigation firm, is probably going to be information gathering. You're going to be wanting to get the accident report. Again, you want to get a certified copy of the accident report. I'll explain why you want it certified here in a minute. You're going to be obtaining medical records and billing records, and these are different, and you may be requesting it from different people as well. Again, the accident report you can obtain from, say, DPS and the larger one. They have a form to request it online. You can also request things like the driving record of the defendant. Again, online, you can get that from DPS. They have just a form that you fill out and to obtain that. Medical records, you obviously get that from the medical provider, whether that be a doctor or a hospital or whoever it may be. Billing records you often obtain from the provider, the doctor, but sometimes they have a third-party billing administrator where you get their billing records from them. The only way to find this out is to call and ask them, although some of the bigger ones, you go to some of the big hospitals, Methodist Hospital, Herman Hospital, you can get that information online as well. Lost wage information, you can get that typically from your client. Hopefully he can get that for you from his employer. The vehicle repair records, again, you might be able to get that from your client, and or otherwise you may have to go do some research, like on that accident report, on where that the vehicles were taken to. You may want to get not just your plaintiff's vehicle repair records, but your defendant's vehicle repair records. How badly their vehicle was damaged is relevant to the severity of the accident. Now, you want to prove up these documents very early along in the case to avoid possible hearsay objections. Prove up is a term of art. Basically means get them ready for trial to avoid hearsay objections. I'm sure you're asking what hearsay is. Hearsay is a statement. This is Texas Rules of Evidence, Rule 801. It's a statement made by the declarant, or other than made by the declarant, while testifying at trial or hearing, offered in evidence to prove the truth of the matter asserted. They define a statement as an oral or written verbal expression, or it could be a nonverbal expression. Declarant as a person making the statement, and matter asserted includes any matter explicitly asserted and any matter implied by the statement. I'm sure this is clear as mud what hearsay is. For our purposes, hearsay is basically any statement other than made physically at trial or the hearing, or at a deposition for the hearing or for the trial. Rule 802 of the Texas Rules of Evidence is commonly called the hearsay rule, which states that hearsay is not admissible except as provided in the statutes or the rules. The fact that it's not admissible, what that means is if it doesn't come from the witness stand, then cannot be presented to the jury or the trier of fact. So if you think about this, if we don't allow any hearsay, then you have to call down the mechanic who fixed the car to testify. You have to call the doctor who did the work to testify. This becomes unwieldy, and virtually any trial then is going to require hundreds of witnesses, as well as take 4 to 6 weeks for even the simplest trial. Therefore, we have developed Rule 803 of the Texas Rules of Evidence, which are exceptions to the hearsay. And what that means is that with these certain exceptions, we will allow hearsay to be admitted into the record and at trial. Now, for our purposes, while there are many hearsay exceptions, we will concentrate on just a few of them. First of them is going to be records of regularly conducted activity. And basically what that means is if someone makes a record as part of the normal course of business, such as, say, a hospital does with their records, is the most common one. It could be anything, though. A mechanic shop who makes a record of the work that they do and the parts that they use. That's a record of a regularly conducted activity. Then you can get that admitted into trial so long as you attach it to an affidavit, which conforms to Rule 902, which I'll show you here in a moment, to get them admitted at trial. Again, I like to, and I encourage you to prove up. That's what this is called. You get the affidavit signed and you get copies of the records and get them ready for trial very early. Otherwise, you'll find yourself 2 days before you need them trying to get affidavits signed, and sometimes that can be impossible to do. The second exception that's relevant to our class is certified copies of public records. This, again, is an exception to the hearsay rule, and these are admissible to trial. So this is why when you request a copy of an accident report, which is a public record, that you may get a certified copy. You usually pay a small fee, $5 to $10 to get a certified copy, and that way it's admissible at trial. And again, you want to do that early in the process, because dealing with any government official, sometimes you just can't get things done immediately. So there's a process that has to be gone through. The Rule 902, which is the affidavit, which requires those records that we're trying to get admitted, those records of regularly conducted activity, is the rule explaining the affidavit. Now, business records must be filed at least 14 days prior to trial. Oftentimes, the court will have a scheduling order which requires them earlier than 14 days, but under the rules, they have to be filed at least 14 days before trial for the records to be admitted. The rules are nice enough to provide a form affidavit. Now, keep in mind that you do not have to use this affidavit. You just have to substantially comply with this form. But I ask you, if they give you the form, why you wouldn't use it. And I greatly encourage you to use this form. It is a very simple form affidavit. Basically says that whoever the custodian of records is for whoever's records that you are attaching to, be it mechanic shop, be it whoever, that they are the custodian of records. They're attaching X number of pages from whatever the name of the business is, and that they're kept in the regular course of business, and that they're kept by an employee with knowledge of the act, event, condition, etc., and that the records are the originals or exact duplicates of the originals. Very common form. I encourage you to use it, not to try to make up your own. It'd be kind of silly to make up your own after the rules provide you with this, but this is the form to prove up business records. Now we have a special rule regarding medical bills. This is the Civil Practices and Remedies Code, section 18.001. I think I told y'all in the first class that there's no way to make some of this stuff exciting. These are just the rules. What this is, it's an affidavit concerning the cost and necessity of services. Basically, this is for medical bills. This involves whether or not, if you get this affidavit signed, the billings are admissible at trial. Again, you must offer this affidavit at least 30 days prior to trial. So while your medical bills and other bills are required to be filed at least 14 days prior to trial, your medical bills must be filed at least 30 days prior to trial. That is because the other side can file a controverting affidavit saying that the records are not part of the are not that the services provided and charges made are reasonable, which the original affidavit must say. So they can file a controverting affidavit saying that the charges made are not reasonable. Then they can do that 14 days before or after you file your affidavit. So that's why the 30-day requirement is there. The counter affidavit must give reasonable notice of why they do not think that the services provided were reasonable or the charges were reasonable and or necessary, and they must be made by a person who is qualified to make it, meaning an attorney cannot make an affidavit saying that the charges made by a doctor were not reasonable. That would have to be made by a doctor. It used to be quite common to see these counter affidavits. Don't see them nearly as often as you used to, and I don't think it's something that you'll often see in y'all's practices. Again, the code is kind enough to provide us a form affidavit. It actually provided you 3 different forms, which you are to choose just one of these 3. And again, these are for your medical bills, how to prove up your medical bills, which again, if you were in litigation, is going to be a very major part of your job. The first form, under section 18.002 of the Civil Practices and Remedies Code, subsection A, is when the doctor themselves actually provided the services. You can see here on such and such date, I provided a service to plaintiff, and then you attach the billings. Quite frankly, doctors never sign this affidavit. I doubt if you will ever in your practice use Form A. Doctors just have staff to do this. The doctor will not be signing this. More commonly is Form B to section 18.002. This is when the person in charge of the records is going to be signing this. This could be a office manager, a secretary, it could be a billing service, could be virtually anyone. This is when you're attaching an itemized statement of the bill, and the doctor has been paid in full, so by an insurance company or by the plaintiff themselves or whoever. You use Form B. This is probably the most common form that you will be using. Form B1 you use if the doctor has not been paid in full. Again, this is for the custodian of record, and it says the same thing as Form B, but it says the total charges were X. I have been, but there remains unpaid is Y, and I am entitled to be paid Z in the future for my services. Again, a pretty common form. You use one of these three forms for your billing records, for medical billing records. Remember, these are only for medical billing records. You do not use all three. Pretty common in your assignment. You're going to be doing one of these, and it's pretty common for me to get turned in all three instead of the one form that is actually needed. What you're going to do when you need these affidavits signed, you prepare a letter. Typically I will call, or paralegal will call in advance to find out who to send it to, whether or not it's the hospital information, or it could be a doctor's office, could be a third-party billing administrator. They will almost always have a fee for this service. So this is, again, going to be a primary part of your job. You call the hospital, find out where do you send for the billing records, where do you send for the medical records. They are very often different, especially for a hospital. Now, a lot of this information may be online, but you may have to call as well. It depends upon the size of the entity that you're dealing with. Again, they usually charge you a fee, and they won't send it to you unless you do send that fee in. You attach one of those or both of those affidavits, one for the records, one for the bills, and ask them to fill it out and sign it. You also need to attach a HIPAA release. This is a federal law, HIPAA, which you should be familiar with. Health insurance portability, I can't remember what HIPAA stands for anymore, but they will not release the records to you unless you have a release signed by your client. Now, I will tell you that some of your larger entities and hospitals require their own forms for this. They will not release it based on your form. They have vetted and want to make sure that it has all the required information. So you can do everything right, but if you don't request their forms, you will not get your records. The release is obviously signed by your client. And the only way to know if they have their own forms to do this is to get online and or to call and find out if they have their own forms in which to send to them. Now, we have our new assignment for this class. This is, again, this is the form that all future assignments are going to take. It's just like if you were my paralegal at my firm. We signed up a new case today, and this case will be the basis for all future assignments. We represent Harry Plaintiff. He was involved in an auto accident against Mary defendant. I'm attaching a copy of the accident report. part of what was redacted is the fact that Mary defendant was driving a vehicle owned by Exxon. We believe that she was an employee of Exxon. She was killed in the auto accident, unfortunately. There has been a probate in which her daughter is the executor. Her name is Susie defendant. So any notices have to go to Susie for the estate of Mary defendant. Our client was taken to Herman Hospital in the medical center. So I want you to send representation letters to all the defendants. I want you to obtain a certified copy of the accident report. I want you to obtain a certified copy of the defendant's driving records. And I want you to prove up the medical records and bills for our client from Herman Hospital. I want you to prepare all the documents that are necessary to do this and get them turned in. Again, I'm traveling. I'm going to have limited access. You cannot, I'm out of the country. I'm actually in London. So you're going to have to send me an email, and I will try to respond as quickly as possible. But it could take me a day or two to do so. But I will answer all questions. Good luck to you, and I look forward to seeing you next class.